Welcome, everyone, to the PCI Practical Matters podcast. This is Top 10 Tips and Traps for Bid Protests, Part 1. We're joined today by Cy Alba. Take it away, Cy.
Hey everyone, welcome. I'm Cy Alba. I'm a partner in the law firm of Polaro Mazza. We deal with many protests every year, so I figured this would be a good way to kick this off, talk about bid protests, how things work, how they function, and what really things to avoid, including some of the latest case law out there that kind of traps people. So, kicking things off, let's talk about first like tips and tricks. So, how do you calculate timeliness? Like whenever protests come in, it happens all the time. Like a client will call, they'll say, "Hey, I want to protest something." Sometimes it's too late. Sometimes the protest is due in an hour, and it's not possible at that point. There's a lot of issues that come up with the very strict timeliness rules when you're dealing with bid protests. So there are a few places you can go, right? With protests, you can go to the GAO, you can go to the Court of Federal Claims, or you can go to the agency. Now, putting aside FAA has ODRA, that's a whole different world, so that's sort of outside the scope. What we're talking about here are the three main areas: GAO, Court of Federal Claims, and directly to the agency. When you're dealing with timeliness, GAO and the agencies are treated basically the same. You have 10 days from when you knew or should have known to file a protest and be timely. There's something about getting the stay of performance, and that's sort of a separate issue we'll talk about later. But if you just want to be timely and not be dismissed because you're untimely, you have 10 days from when you knew or should have known. Generally, for post-award protests, that's 10 days after the award or after you got a particular notice. Also, if you got a debriefing that is a required debriefing, which we'll get into that as well later, if it's a required debriefing, you have 10 days from that debriefing date to file, even if that 10 days runs after the 10 days from award or 10 days from when you knew or should have known. But that's only for required debriefings. Again, we'll get into that later. These are both true for agencies and at GAO. And it's 10 days generally from when you knew or should have known. That is somewhat subjective. The facts can change. So if it's an award issue, it's probably from award. If it's an issue of getting excluded from the competitive range, it's 10 days from that date. There's various triggering events that can occur. And anytime you have some sort of event where you know the agency has taken some sort of adverse action against you, that generally is when your clock starts, and it's calculated as calendar days, not business days. So again, very short timelines. If you got an email and you were on vacation, you didn't see it till 7 days later, the next, like let's say you got it Monday, you didn't see it till the next Monday, you only have 3 days left. So, these things are very tight. Now, if you miss that timeliness window, you can still go to the U.S. Court of Federal Claims. The U.S. Court of Federal Claims generally doesn't have the same sort of timeliness requirements that GAO and the agency does. There can be issues if you're filing a pre-award protest, but again, we'll get into that as well in a little bit. So just know if you're outside of the 10-day window for GAO or the agency, you might not be completely out of luck. You could go to the U.S. Court of Federal Claims. You don't get the automatic stay at the Court of Federal Claims, but you can still file your protest. You can go through the whole process. So let's talk about next, you said GAO, you said the agency, where am I supposed to go? What's best? If I have a protest, where should I go? Where should I file a protest? Well, if you file a GAO and you get in within that timeline where you're timely, and if you filed within 10 days after award or within 5 days after you got your debriefing, then you actually get an automatic stay on the award. If you're filing a pre-award protest, which again, we'll get into the specifics of that, but if you file a pre-award protest in a timely manner, then the agency can still evaluate proposals, but they can't make an award. So that's where if you get the stay at GAO, it's automatic. Same thing with the agency, but it's an automatic stay. Also, there is a 100-day turnaround time at GAO. So once you file at GAO, they have 100 days from the date you file to make a determination. That kind of thing doesn't necessarily exist at the court. It depends on the judge's schedule. It depends on the briefing schedules. You can also look at the timeline at GAO, and you can look and say, all right, I filed my protest on day 1, day 30, the agency is going to issue their agency report. 5 days before that, they're going to give me a list of all the documents. I have 2 days from that date, once I get the documents, to object. Then when I get the agency report, I have another 2 days to object. Then 10 days after the agency report shows up, you have to file your comments. And if there's a supplemental protest, then at that point, GAO will set briefing deadlines for when you have to file supplemental comments, and that process can continue. But all of that has to happen, and GAO has to make a decision within 100 days. So you know that's going to occur. Generally, GAO takes the full 100 days. So it's something where you can plan ahead, but it's probably going to take that long of a period. If you're at GAO, the agency is going to be represented by agency counsel. It's not going to be DOJ. It's not going to be anyone else. It's going to be the counsel for the agency you are protesting. That gives you some opportunity potentially to negotiate. There's not as many strict rules and policies and procedures with agency counsel and how they deal with bid protests as opposed to DOJ, which is at the court. So if you go to the Court of Federal Claims, though, there is no, like I said, strict timeline. It's all determined by the judge. You'll usually file something. You'll get a status conference. At that status conference, the judge is probably going to ask you for what the timeline is going to be. Have the parties agreed on a briefing schedule? And based on that briefing schedule, that will tell you when you're probably going to have a hearing. And then when after that hearing, when the judge comes out with their final opinion on the matter, they could do it at the hearing. They could do it even without a hearing. Or sometimes if it's complicated issues, it could take a while. The judge might take months to issue an opinion. So know that as well. You can have the whole process done in less than 100 days, or more likely it'll be around 100, 120 days. Or if the judge is very busy or it's a complicated issue, it might take even more time. So if time is of the essence, that's something to think about. Also, if you go to the Court of Federal Claims, you do not get the automatic stay on either award or performance of the contract. You don't get that stay. You have to actually argue for that. So when you go into the court, one of the first things they might do is set a schedule for a hearing on preliminary injunctive relief or a temporary restraining order. You might have to go in and argue that. And that is another round of briefing. You have to file a motion for permanent or preliminary injunctive relief, motion for temporary restraining order. You have to have a memorandum in support of that. Then you have to go into the hearing and argue that point. And if you're successful, you get the stay. And then after that, whether you're successful or not, then the real case starts from there. And that initial process can be time consuming as far as drafting all the motions, putting everything together, arguing the case. There's a lot of work that goes into that. Sometimes the Department of Justice will talk to the agency because you're in a court. Because you're in a court, the agency counsel is not representing the government. The Department of Justice is representing the government, no matter what agency it is. So when you're sitting there, DOJ might agree to a voluntary stay as long as the period of time that's agreed upon for the briefing schedules and the hearing are short enough to give the agency the time it needs to get the procurement going, no matter what the court's determination is at the end of the day. So because you're dealing with DOJ, though, they also have more procedural rules. There's a lot more policies that they have to abide by, things of that nature. So it can actually get you further down the line faster than even going to GAO if you have a very expedited briefing schedule. But you just never know going in. You never know if you're going to get the stay of award because it's not automatic. You don't know if they're going to agree to it. You don't know if they're going to have to argue it. And so it can be expensive to get in and do that. The other piece of this to remember is that it is an actual court. And companies, by law, cannot represent themselves in court. You have to be represented by a lawyer. At GAO, you could file your own protest. Many times they're not that good, but you could try to file your own protest at GAO. You cannot do that at the Court of Federal Claims. If you try to file a protest by yourself at the Court of Federal Claims, you will be dismissed for lack of standing because you filed it without an attorney. You're not allowed to do that. So that can be looked at as a downside to the Court of Federal Claims, that you have to go through that process. Whereas GAO, you can throw whatever at the wall and see if it sticks. Let's see. Another piece of this, at GAO, the agency might try to limit the record more strictly. So you're not going to get as many documents as you otherwise would. Whereas if you go to the Court of Federal Claims, the Department of Justice general policy is to provide all documentation that is relevant to the protest, which is usually everybody's proposal, all the source selection documents, potentially even communications. There's a lot of information that you would get, and your counsel can go through those documents and try to see what other arguments there are. So even if you don't have the best arguments right out of the gate, there might be ways to go through the record and try to bolster those arguments and make them stronger after the filing. Moving on to then the third topic here, we've talked about GAO, we've talked about the Court of Federal Claims. What about agency level protests? So if you don't want to go to GAO, which is sort of a middle ground of maybe upsetting the agency because now you have a third party looking at them, there's some formalities to it, but not as much formality as with the Court of Federal Claims, not as much of the motions practice and the various hearings and moving for injunctive relief and all that stuff. You don't have to worry about that at GAO. The agency is even less formal than GAO. It is the least formal option. And it's also, I think, the sort of nicest option. If you're trying to sort of throw down a gauntlet, but do it with velvet gloves, so to speak, the agency level protest is the way to go. Agency level protests are just like a letter. It's very similar to a GAO protest. If you're writing it well and you're trying to do a good job, it's going to be the same level of effort as a GAO protest, even though it's less formal, because you still want to present everything to the agency. You still have to argue about why you're timely, why you have standing, why you were prejudiced. All of that still has to go into the agency level protest. And usually I would say a good protest is many pages long. It's not a few paragraphs. If you're really trying to convince the agency and it's not just a clear open and shut issue, you're going to have to cite case law just like you would at GAO and just like you would at the Court of Federal Claims. Again, it's just less formal. You can represent yourself at an agency. You don't have to have a lawyer, unlike with the Court of Federal Claims. And some of the issues, though, I will say, if you're representing yourself, whether it's at GAO or it's at the agency, you will not have access to any documentation because there's likely going to be a protective order in place. The only people that can look at the documentation that we talked about are people who have a protective order. We'll get into more of that later as well. But that can be a burden for a pro se litigant or a pro se protester. Further, as you go to the agency and you're going through some of the process there isn't a response mechanism where the agency has to send you their response to your protest and then you get to file a reply. No, it doesn't work like that. At GAO, like I said, there's the agency report and then the comment period. At the Court of Federal Claims, you have motions back and forth. You have a motion for injunctive relief. You might have a motion for judgment on the administrative record, and then you have responses and you have replies, and it goes through a lot more of that process. At the agency, you send the letter, then the agency makes its determination. There is no really strict timeline as to when the agency has to make that determination, but just know if you file a timely agency level protest, there is an automatic stay on either performance or award, depending on the time that you file it. And the agency, no matter what they say, that allows you to then file another protest if you wanted to. If the agency denies your protest or they don't give you what you want, you have 10 days from the date of that notice. You could go to GAO. Or you could go to the Court of Federal Claims instead of GAO. Or you could go to the agency, they give you a bad decision, 10 days later you go to GAO, you're there for 100 days, you lose at GAO. If you take that step, you can then go to the Court of Federal Claims. And the Court of Federal Claims generally reviews protests de novo, which means they're not going to necessarily pay attention to what the agency said or what GAO said. They look at it as a new case and give their own opinion. There have been more cases recently where the Court of Federal Claims has overruled GAO. So it's just a good thing to keep in mind that when you're dealing with those sorts of things and you're dealing with stuff that you do have multiple avenues to go by, it just takes more time. There's also not the kind of rule like with claims and appeals. If you submit something to the contracting officer in a claim context, if you don't put everything in there, you're out of luck. You can't raise it on appeal. With protests, if you file a protest with the agency and then you say, well, we lost, now we're going to hire a lawyer, and you hire counsel to go to GAO or the Court of Federal Claims, they can go through and put in a bunch of other arguments that you never even thought of, right? Or they can bolster all your arguments because it's essentially a new protest every step of the way. And then kind of lastly for this sort of original set of key issues, key tips, is circling back to this question of protective orders. So when you're dealing with a protective order, whether you're at the agency, whether you're at GAO, or whether you're at the Court of Federal Claims, there's a lot of sensitive information that could potentially be shared, including, like I said, your proposal, competitors' proposals, source selection information about how they evaluated everyone, what they liked, what they didn't like, meaning the agency, potentially communications between agency personnel going back and forth about a particular solution or what they liked and didn't like. Very, very sensitive information, right? The government's estimates for IGCE, all that kind of stuff. All of that will be turned over, can be turned over to a protester, not at the agency. At the agency, you get none of that. You just file your protest in letter form and you wait and see what the agency says. At GAO and the Court of Federal Claims, though, there will be some documents given over to you and you can go through it. However, anything that is protected information, so usually proposal, source selection, all that stuff that I said, that will only be turned over to individuals who are admitted to the protective order per the processes at GAO and the Court of Federal Claims. Only the people that submit applications to get under the protective order and are approved after being reviewed by everyone else in the case will be given access to that information. The good thing is that your information is protected. The bad thing is that, generally speaking, the only people who can be admitted to protective orders are outside counsel or outside consultants. As part of that process, you have to promise, like when we represent clients, we have to promise not to disclose anything to anybody that's protected, including our own client. That then means that even drafts, not the initial protest draft, that's probably not protected because it's all the information that if a client calls us, they're feeding us that information and we're preparing the protest with everything they gave us and everything we could find publicly. That's not necessarily protected vis-a-vis our client. When we file it, though, we'll request a protective order and we'll redact all of the information that our client wants redacted because there's the possibility that another company intervenes in the protest, maybe your competitor intervenes in the protest, and you don't want them to see all that information. Their lawyers can see it because, again, their lawyers or their consultants have sworn as part of this process that they will not share that information. That includes draft documents that we prepare. We cannot share them with the client. And you can't even share them before you file because you have to get agreed upon redacted versions. And there is no rule at GAO that every document be redacted. If you want the document to be redacted, your lawyer is going to have to go through and redact that and then go back and forth with the agency and other interveners to get everybody's agreement on what should be redacted before that can be released to the public. Sometimes we'll have, instead of a public version, we'll have a version that is for one client or another company, if it's an intervener, just for that company. That, again, has to be agreed upon by all the parties. So if everyone wants that, that's extra work that you're going to have to put in, or your lawyers are going to have to put in to make sure that that process is complete. It can also be very frustrating for clients because you can't know what we're seeing. So if we file a protest that has 4 arguments, we get the record from GAO and that process from the agency, or at the Court of Federal Claims, we get the record in that process. We go through it and we see that none of the 4 arguments we made are viable. They're all dead in the water. However, there's 2 other arguments that are really good. We can tell you that we went through the record and we think that the protest is worth pursuing because there's a couple arguments that we think we need to make. We can't tell you what they are. We can't tell you details about why we think they're great arguments. We can just tell you we think they're pretty good and you have to trust us. If you decide to do that, then we go forward. We can file the protest document, the supplemental protest grounds with those new issues. And again, we can't share that with you. Even after we file it, we can't share it with you because it's all based with protected information. If you want a copy of it, we can go through that whole redaction process, get agreement, and give it to you. So that sort of frustrating process is how things work when you're dealing with protective orders in order to protect your information and others' information. Remember, when you're filing a GAO or the Court of Federal Claims, the other company, like the awardee, for instance, they can intervene. And you don't want that intervener fishing through all your documents. You don't want their lawyer sharing all your secret sauce with their client who's your competitor. So that's why, as frustrating as it can be for you that we can't share the information, it's also important that the other parties aren't sharing the information to protect you and protect your bid and protect the whole integrity of the government procurement process, even though that these protests are still allowed. So that's kind of a quick overview of some of the first 4 sort of tips, general rules, general guidance dealing with bid protests at GAO, at the Court of Federal Claims, and at agencies, and things to deal with and handle. Next, we're going to get into issues that are a little bit more in depth, dealing with stays of performance, solicitation defects, how debriefings work, whether they trigger different rules. And so stay tuned for that, and we'll see you next time.
Thank you. This has been the PCI Practical Matters podcast. We'll be back again with part 2 in a few weeks.